The hearings will resume on the confirmation proceedings for Judge Samuel Alito to the Supreme Court of the United States. Morning, Judge. Saw your family in the hallway as we were coming down. Everybody appears to be bright and rested and ready.
Thank you, Senator.
The committee staff, accompanied by representatives of Senator Kennedy, went through the Russell files yesterday, finishing up their work, I'm advised, at about 2 a.m. this morning, and provided me with a memorandum that the committee staff reviewed more than 4 boxes of documents from the personal files of William Rusher concerning CAP. Judge Alito's name never appeared in any document. His name was not mentioned in any of the letters to or from the founder, William Rusher. His name was not mentioned in any of the letters to or from CAP's long-term executive director, T. Harding Jones. His name does not appear anywhere in the dozens of letters to CAP or from CAP. The files contain canceled checks for subscriptions to CAP's magazine Prospect, but none from Judge Alito. The files contain dozens of articles, including investigative expos written at the height of the organization's prominence, but Samuel Alito's name is nowhere to be found in any of them. The Rusher files contain lists of the board of directors, the advisory board, and the contributors to both CAP and Prospect magazine, but none of these lists contains Samuel Alito's name. The files contain minutes and attendance records from CAP meetings in 1983 and 1984, just before Samuel Alito listed the organization on his job application, but Samuel Alito did not attend any of those meetings, at least according to those records. He was not even mentioned in the minutes. The files contain dozens of issues of CAP's magazines, but none of the articles was written by, quoted, or mentioned Samuel Alito. CAP founder William Rusher said, quote, "I have no recollection of Samuel Alito at all. He certainly was not very heavily involved in CAP, if at all." Before turning to Senator Leahy for his allotted time, I'd yield to him if he has any opening comments he chooses to make.
Well, I think, Mr. Chairman, as we know, this will be the last opportunity for the American people to learn what Judge Samuel Alito thinks about their fundamental constitutional rights, whether he's going to serve to protect their liberty, their privacy from government intrusion. I think it's even more critical today because of the efforts to expand presidential.
Excuse me, Senator, do you want to start on your 25
Oh, no,
minutes?
I thought you were asking me if I had.
No, I do, yeah, opening comments, sure, yeah. We're not going to start your time clock until you tell us.
No, it's just a short opening comment. I just think it's critical, and I know the judge probably feels like he's been here and doing nothing but being on a hot seat, but he is talking about a lifetime appointment, and it is the most powerful court in the land. It is at a time when we see this effort to expand presidential powers, such as illegal wiretaps on Americans, the president using a signing statement to create exemptions to laws prohibiting torture. These are all important things. The Supreme Court's our ultimate guardian, has to be our ultimate guardian, and we need to know whether Samuel Alito is willing to be that kind of guardian. I'm still troubled by some of the questions, and Mr. Chairman, I know you're going to be asking questions, and I'll wait to ask mine after that, of course.
I'm going to reserve my time at this juncture and turn Senator Leahy for time up to 25 minutes.
Thank you. In his confirmation hearing last September, we, as you know, went through hours and hours, days and days with Judge Roberts, now Chief Justice. I asked him if the Constitution permits the execution of an innocent person. He said if they've been falsely convicted and they're innocent, they shouldn't be in prison, let alone executed. I think we'd all agree with that. But I pushed further because my question was whether the Constitution permits the execution of an innocent person. If you know that they're innocent. He said, I would think not. Judge, do you agree with Chief Justice Roberts?
I agree that it is one of the most fundamental rights protected by our Constitution, that no one may be convicted of an offense unless they're proven to be guilty beyond a reasonable doubt. And further than that, the Supreme Court's decisions since 1976 dealing with the Eighth Amendment have attempted to create a whole set of procedural safeguards to make sure that the death penalty is not imposed arbitrarily or capriciously. And this whole framework is designed to prevent exactly that, to prevent the conviction of an innocent person and to prevent the imposition of capital punishment on someone who is innocent or on someone who is guilty of the offense but is not deserving to have that penalty imposed on the person.
But Judge, we have, as we know, we saw this the cases in Illinois, people a few days away from execution. They've been sentenced to death. They've been convicted. They had their trial, gone to trial. Jury came back. Apparently, procedures followed on sentencing. They're now sentenced to death. A few days before death, somebody comes forward, very last minute because of DNA evidence, and says, whoops, we got the wrong person. And then they're let loose. We're finding in Virginia now in other cases, it appears that there's a possibility a number of innocent people were executed. What if you had a case? They've gone through the whole thing. They've been convicted. The judges followed all the appropriate sentencing. The jury came back for sentencing. Did everything following the law. And now they're up for execution. Evidence comes up, let's say DNA evidence, or DNA evidence, a confession of somebody else. Would it be unconstitutional then to execute that person?
Well, Senator, it is unconstitutional to execute someone who has not been proven guilty beyond a reasonable doubt. Now,
But they may have been found guilty beyond a reasonable doubt, what I'm saying. And then, as a lot of these people were on death row and then had to be commuted at the last moment when a few days before their execution, they found, whoops, we got the wrong guy.
well, that's the ultimate tragedy that could possibly occur in our criminal justice system, and we should do everything we can to prevent that from ever occurring. And I have not had a case during my time on the Court of Appeals. I've had only a handful of capital punishment cases where there was a suggestion that that was a possibility. If the evidence develops at the last minute, then I think, and if this is it would depend to some degree on, the procedures would depend on, would be different if, depending on whether the person had been convicted in state court or in federal court. The first procedural step in either instance would be to file a petition with the trial court. It would be, if it were in state court, it would be a state collateral relief petition, and those are handled differently depending on the state. And then or file you could go to the state court, or you could file a second habeas petition, attempt to file a second habeas petition in federal court, and follow the procedures that are set out in the habeas corpus statute.
But you agree with the basic, and I understand all the steps, like you as a prosecutor, even though we don't have the death sentence in Vermont, we do have real life imprisonment, and I remember those. But you agree, though, with Chief Justice Roberts that the Constitution does not countenance the execution of an innocent person.
Constitution is designed to prevent that.
So, and the reason I ask this, there was this is something that originally raised, as I recall, in the Judiciary Committee by Chairman Specter, the rule of 4. Are you familiar with that with the Supreme Court? In other words, if it takes five justices to stay an execution, to hear or to hear one of these cases, usually if there's been 4 that have agreed it should be, somebody will make the 5th, just as a matter of courtesy. It hasn't been followed that much recently. Chairman Specter has called it a bizarre and unacceptable outcome to not provide the 5th vote. He once introduced legislation to codify the rule of 4. If you are one of the justices and you're there and these things always seem to happen, everybody's scattered all over the place, 4 of your fellow justices have said that they would hold, what would you do? They voted to stay at execution. They're asking you to be the 5th vote.
I had not heard of this rule until the hearings for Chief Justice Roberts, but it seems to me to be a very sensible procedure, because I think we all want to avoid the tragedy of having an innocent person executed or having anyone executed whose constitutional rights have been violated.
Well, I raise it as I did with then Judge Roberts here, because some things you remember from this hearing, some things you probably try to forget from this hearing, both you and your family, but I hope this one, at least this idea, stays in your mind. About a decade ago in Washington versus Glucksberg, the Supreme Court declined to find that terminally ill patients had a generalized constitutional right to physician's aid in dying, preferring the matter be left to the states. The court noted, throughout the nation, Americans are engaged in an earnest and profound debate about the morality, legality, and practicality of physician-assisted suicide. Chief Justice Rehnquist wrote, the court's holding permits the debate to continue, as it should in a democratic society. I remember reading that. I thought a very practical, aside from the legal thing, very practical response. Now, last spring, we witnessed a fierce legal battle over the medical treatment of Terry Schiavo. She was in a persistent vegetative state for more than a decade, and ultimately, after she died, the autopsy showed that. But we found politicians rushing to the cameras, engaged in extraordinary measures to override what the state courts had determined to be her own wishes. State courts had heard countless cases on this. Suddenly, this became the thing, politicians all over the place rushing forward. The power of the federal government was wielded by some to determine what, in my view, are deeply personal choices. The president even came back to Washington in the middle of one of his vacations to sign special legislation on this. Do you agree with the idea advanced in the Cruzan case that the wishes of an unconscious patient, to the degree they can be known, should govern decisions regarding life-sustaining therapies? Let's assume that the wishes are clearly known. Should they be followed?
Well, the Cruzan case proceeded on, assumed for the sake of argument, which is something that judges often do, that there is a constitutional right to say, that each of us has a constitutional right to say, I don't want medical treatment. And the Cruzan decision recognized that this was a right that everybody had at common law. At common law, if someone is subjected to a medical procedure that the person doesn't want, that's a battery, and it's a tort, and the person can sue for it. It is illegal. The court did not.
One of those cases where we got something from that foreign law, in this case, English common law, is that correct?
Well, that's correct, and I think that our whole legal system is an outgrowth of English common law. And
Just thinking of somebody, why that popped in my mind. I was thinking of some of the people talking about paying attention to foreign law. Most of our law is based on foreign law, but go ahead.
Most of our
Common
law
law.
is an
Common
outgrowth of English common law, and I think it helps to understand that background often in analyzing issues that come up.
But you agree with Cruzan? I mean, I'm thinking if somebody has a do not resuscitate order, do you agree with that?
That's a fundamental principle of common law, and Cruzan assumed for the sake of argument that that would be a fundamental constitutional right, but that is a right that people have had under our legal system for a long time to make that decision for themselves.
My wife was or is a nurse, and when she was working on medical surgical floor, and she had mentioned about people with these DNR, do not resuscitate. If would you agree that a patient would have a right, for example, if you have a living will, you have a right to designate somebody who can speak for you in a case of you've been a terrible injury, you're unconscious, to speak for you on a do not resuscitate or do not use heroic measures, all the rest? Do you agree with that?
Yes, Senator, that's, I think, an extension of the traditional right that I was talking about that existed under common law, and it's been developed by state legislatures and in some instances by state courts to deal with the living will situation and with advances in which I think is in large measure a response to advances in medical technology which create new issues in this area.
When we if we have three separate and co-equal branches of government, as Constitution says, have these checks and balances, I think most of us feel if the Congress is going to carry that out, they have to carry out real oversight, make sure the government's accountable to the American people. If you don't do that, corruption, incompetence sets in. We've given a lot of powers to our government to fight against terrorism and others, and the check and balance is to make sure there's oversight. Do you believe in the general principle of the Congress having major oversight powers?
I don't think there's any question about that.
Well, let me go to this, and I was thinking of this as we were talking about the Shivel case. And I don't want you to have to get involved in what many felt was kind of a sorry exercise when people are already suffering enough, sorry exercise by the Congress. But so I won't talk about the House committees. Unbelievable subpoena to Terry Shivel. But let me ask you this. Could this committee, the Judiciary Committee, issue a subpoena for a defendant on death row in a state prison if we believed he was about to be executed and thought he was innocent?
Could this subpoena issue could this committee issue a
yes.
subpoena
And enforce it?
to have the defendant come and testify before the committee?
Mm-hmm. Today, it's an hour before execution, for example, to make it even a tougher case.
It's not a question that I ever thought of. Sitting here, I can't think of an objection to it, but I would have to hear whatever arguments there were to be made.
You know, this may seem to be bouncing around here a little bit. I'm trying to pull together my own mind after looking at the transcript last night, some of the things we're saying, and you were in a discussion with a number of senators about views of the court, or how the courts, how the American people view courts, and how basically in a democracy, courts have to have the respect of people if they're going to be able to carry out their orders. Brown is probably one of the key examples there, where the Chief Justice spent 2.5 years till he got a unanimous court decision. Justice O'Connor gave a speech decrying the present climate of antipathy between the judiciary and some members of Congress, and I've spoken with her and others, the late Chief Justice, about this. She expressed concern about efforts to limit federal court jurisdiction in areas that some members of Congress think the federal court should not be involved. We've seen a number of efforts to strip the federal courts of jurisdiction when some members of Congress felt they disagreed with it. Now, I thought some of these issues were settled by Marbury. And when Chief Justice Marshall said it is emphatically the province and duty of the Judicial Department to say what the law is. Now, the court stripping bills are not without precedent. Recent efforts have failed. I recall one where 3 senators finally talked it down until it ran out of time. I was one of the 3. Senator Lowell Weicker of Connecticut was one of the other 3. On the way out, the third one put his arm around us and said, I think we're the only true conservatives in this Senate. We both said, thank you, Barry Goldwater. We appreciate you joining us in this. I took it as a great compliment. Now, imagine that in the early 1950s, Congress enacted a law that purported to strip all federal courts, including the Supreme Court, of jurisdiction to hear cases and appeals involving the segregation of public schools. Would such a law have been constitutional?
Well, there's a debate among scholars about the extent of the authority of Congress to structure the appellate jurisdiction of the Supreme Court. And there are those who say that Congress has the authority to eliminate appellate jurisdiction by topic, and there are those who say that if and they rely on the language of Article 3, and there are those who say that to take away jurisdiction over a category of cases such as that would be a violation of another constitutional provision, in that instance, a violation perhaps of the Equal Protection Clause. And there's this debate. It's not something.
Have you taken part in that debate?
Pardon me?
Have you taken a position in that debate?
I have not taken part in that, and I've read.
Would you like to?
Not at this time.
I don't know why that surprises me.
It's and the case law is not definitive on this question, according to the scholars. Ex parte McCardle is a case that can be interpreted in a number of different ways.
You know, we had many in the Congress at that time. Had they thought the Brown versus Board of Education was about to come down the way it did, probably would have made efforts to strip the authority of the Supreme Court to hear it. So, and I'm afraid that as we find some of these efforts where the courts become a very convenient whipping boy to people looking for votes or whatever, that might happen again. And I suggest you think long and hard on it. Let me ask you this, and probably what's more apt to find out. More than one occasion, the House of Representatives has included a provision in an appropriations bill, and we all agree that the Congress has the power of the purse, but an appropriations bill saying that none of the funds can be spent enforcing a particular court decision. Pick something that they feel is unpopular at the moment. So they say no money can be spent to enforce it. Would and let us say the court has ruled basically a constitutional issue, saying this shall be enforced, The Congress says, no, we won't allow money to be spent. Does that violate the Constitution?
Well, that's also a provocative constitutional question. I can't recall an instance where that has been done with respect to a constitutional decision. Perhaps it has been. I do recall back during the 1980s that it was done with respect to an issue of antitrust. And I would assume that if there wasn't, well, obviously if there isn't a constitutional question raised by that limitation on the expenditure of funds, and if you're talking about a non-constitutional question, maybe there is no constitutional issue raised, there wouldn't be an obstacle to Congress's doing that. With respect to a constitutional question, that's a provocative constitutional issue that I don't know the answer to it, and I cannot think of precedent on that point. I don't believe there is any.
Well, let's take a non-constitutional. I want to make sure I understand your answer. The Congress decision has come down of whatever nature. You mentioned antitrust. Whatever it is, comes down from the court, and it is going to require some enforcement. And the Congress says, no, we're not going to put the money in there. Can the Congress do that?
Well, I'd have to know the facts of the case and hear the arguments on both sides of it. Unless there was a constitutional objection, then that falls within one of the most important powers of the Congress, the expenditure of funds. Congress exercises. The framers wanted Congress to have the control of the purse because Congress is the branch that's closest to the people. And I would think that, and Congress obviously has great latitude in this area. I don't know what constitutional objections would be raised to doing that with respect to a non-constitutional question, but I'd have to understand exactly what was going on.
Well, it's something to keep in mind because that may happen. If we can grandstand, if Congress can grandstand the way it did on the Shivo case, you have to wonder what else may come down. One of the advantages or disadvantages of being here for a long time, I've actually been here for the hearings on every member of the Supreme Court, including that of former Chief Justice Rehnquist. And Senator Specter and I have served here together a long time, and I went back to one of his questions. He asked then Justice Rehnquist whether Congress can strip the Supreme Court of jurisdiction over First Amendment cases involving freedom of speech, press, or religion. And I think the chairman remembers this. He can be a rather tenacious questioner, as I know when some of my weekend phone calls from him. But he kept pushing then Justice Rehnquist until he finally got an answer. In the end, Chief Justice, or then Justice Rehnquist, gave his view. He said that Congress could not remove the court's jurisdiction over First Amendment cases. So let me ask the same question that Senator Specter asked in 1986. Does Congress have the authority to say the Supreme Court does not have jurisdiction over First Amendment issues of freedom of speech, press, and religion?
Well, I would give the same answer to that I gave to the more general question you asked a few minutes ago about taking away the Supreme Court's appellate jurisdiction over a topic of cases. It's not a question that I have obviously had to deal with in my capacity as a judge or something that I've written about or studied in any sort of a focused way. My understanding of the writing on the question is that there's a division of thought among leading constitutional scholars on the issue, and there are some who argue that Congress has plenary authority to define the appellate jurisdiction of the Supreme Court, and there are others who argue that if Congress takes away the authority of the Supreme Court to hear a particular type of case, that there could be a violation of another constitutional provision, and in that instance, it would be the First Amendment. And as a matter of constitutional law, I don't feel I can go further than that.
But Judge, this is somewhat similar to the initial answers given by then Justice Rehnquist. But he ultimately came down and said in that hearing that Congress could not remove the court's jurisdiction over First Amendment cases. Are you telling me that, and I just want to make sure I fully understand your answer, you're not willing to go to the extent then Justice Rehnquist did at his hearing?
I gave a speech a while ago addressing this question from a practical standpoint, or touching on it from a practical standpoint, and I said that I thought that doing something like this would be an awkward and undesirable way of proceeding because it would lead to a lack of uniformity in decisions. If jurisdiction is taken away from the Supreme Court, but jurisdiction remains in the courts of appeals, then conflicts in the circuits would develop, and you'd have conflicting decisions potentially in different parts, governing in different parts of the country, and no way to resolve the issue. And if the jurisdiction was taken away from the federal courts in general, then you would potentially have conflicting state court decisions. So the First Amendment, or whatever constitutional provision was at issue, would mean something different potentially in Vermont than it did in New Hampshire or in some other state. So there are undesirable practical consequences of proceeding in that way.
Your answer would be the same if I was asking, I assume, if I was asking the question of the Fourth or the Fifth or Sixth Amendment.
It would be, Senator. I just don't. I have just not studied this issue in enough depth to be able to give an answer. I would have to study it in depth and probably hear it in the context of the case. What I do know is that there's a division of authority among leading constitutional scholars, and I would not want to hazard an answer to the question here without going into the question with studying the question in considerably greater depth than I have.
And this will be my last, and I appreciate the courtesy of the chairman who I might say has run this hearing with total fairness, as he always does. I may have some follow-up questions, all right, but this will be my last chance to ask you anything. Under your theory of unitary executive, are citizen suit provisions, such as those in our environmental laws, allowing citizens to act basically as a private attorneys general and sue polluters, are they constitutional?
I don't see a connection between the unitary executive theory and that issue. And I think Congress has the authority to create a private cause of action for anyone that Congress chooses to create such a cause of action for, subject only to whatever limitations are imposed by the Constitution. But we often grapple with the issue of whether Congress intended to create a private cause of action for a particular class of plaintiffs. That's a difficult issue that comes up with some frequency in federal litigation, but where Congress speaks directly to the question and says that people with and defines the category of cases, the category of plaintiffs who can bring a suit, a citizen suit, or whatever it is, then that's definitive, of course, subject only to whatever limitations the Constitution imposes.
Judge, that's an answer. Substance, what you said is something obviously I would like, but I'm still troubled by it because in November 2000, right after the presidential election, you came and spoke to a meeting of the annual Federalist Society Lawyers Convention about the powers of the president. And when you discussed your theory of unitary executive, you criticized the Supreme Court's upholding the independent counsel statute, among other things. Is your answer today different than what you were saying then?
What I said in that speech was that the Constitution confers the executive power on the president, and when we are dealing with something that is within the president's executive power, without getting into the scope of executive power, and there I was focusing on the president's duty to take care that the laws are faithfully executed. That's explicitly set out in the Constitution, so there can't be any debate about whether or not the president has that power. When we're dealing with something that is within the scope of the president's executive power, the president should have the authority to control the executive branch. And the latest expression of the Supreme Court on that issue at the time was the Morrison decision. And the Morrison decision formulated that the governing standard in what I would call functional terms. And it said that Congress has the authority to place restrictions on the president's ability to remove inferior executive officers, provided that in doing so, Congress does not take away the president's authority to control the executive branch. And I was talking about the importance of maintaining the principle that the president is the head of the executive branch and should control the executive branch.
But you did at that time criticize the Supreme Court upholding independent counsel statute, did you not?
I said that it was inconsistent with what you could call the pure theory of the unitary executive. But at the time, of course, Morrison had been decided, and it was a resounding 8-1 decision, and it is a very important precedent of the court. And
You had been there, it might have been 7-2, is that what you're suggesting?
well, if it comes up before me, if I'm confirmed, then Morrison is a strong expression of the view of the Supreme Court on the question, and an 8-1 precedent on an issue that was important and controversial at the time when it came up before the court. And it was very clear, and as I said, a resounding decision by the Supreme Court on the question.
Well, I am now intruding on other senators' time, and I may do a follow-up question with you. Thank you for your answers. We've obviously agreed on some things, disagreed on others, and I appreciate you taking the time to answer. Mr. Chairman, I appreciate your time.
I'm going to use just a little of my reserve time to comment on what Senator Leahy raised about the issue with Chief Justice Rehnquist on his statement that you could not take away the jurisdiction of the Supreme Court of the United States on First Amendment issues. That was as interesting a dialogue as I've had in my tenure here, and I've had a few, and it arose in a curious context. I'd asked the Chief Justice about the question, and he refused to answer. And overnight, the staff had found an article written by a young Arizona lawyer named William H. Rehnquist in 1958, which was published in the Harvard Law Record, not the Harvard Law Review, but the Harvard Law Record. And in that article, lawyer Rehnquist said that the Senate Judiciary Committee was derelict in its duty in questioning Justice Whitaker at his confirmation hearings and not asking pointed questions about due process or equal protection. And when my turn came, I came back to then Justice Rehnquist and said, how about it? Are you that William H. Rehnquist? And he admitted he was. Didn't have much choice. And I said, well, how about this article? And he emphatically said, I was wrong. But that provided...
He was under oath.
that provided an opening, and I proceeded to continue the line of questioning. And finally, he allowed as to how Congress couldn't take away the court's power over the First Amendment. Seems to me patently clear that the Congress cannot take away the jurisdiction of the Supreme Court on constitutional issues. Cannot do it. That's the principal function of the Supreme Court of the United States, is to interpret the Constitution. And if the Congress could take away that authority, the court's authority would be vacuous. But then, as you might expect, I asked him about the Fourth Amendment, search and seizure, and Fifth Amendment, privilege against self-incrimination. Went right down the line. He refused to answer every question. And then I said, well, why will you answer questions on the First Amendment but not on the rest of them? He wouldn't answer that either. Chief Justice Rehnquist was confirmed 65-33, which confirmed an observation which I have made from time to time. Judge Alito, that nominees answer just about as many questions as they think they have to be confirmed. You may turn out to be a notable exception, but I think that's a valid generalization. And it also confirmed my experience that nominees remember these proceedings, and nominees are influenced by these proceedings in very subtle ways. We don't extract the promises, but when Senator Leahy very adroitly asks you about the rule of 4 on granting cert, 4 justices say the cert's granted, but it takes 5 to stay execution in the capital case. How ridiculous can you be? Senator Leahy wondered if you'd remember that. Well, I predict you'll, if confirmed, remember that. In fact, I predict you'll remember it even if you're not confirmed. But to this day, justices comment to me about questions they had here. Every time I see Justice Souter, he says he still hasn't made up his mind on whether Korea was a war or not. And the other justices, I won't go into any more detail. I'm going to reserve the balance of my 20 minutes and 54 seconds. Senator Hatch.
Well, I'll reserve my my 25 minutes.
Senator Kennedy, recognized for
Thank
up to
you.
25 minutes.
Thank you. Good morning.
Good morning, Senator.
Just to initially follow up on the last area of questioning by Senator Leahy about the unitary presidency. I've asked you questions about this earlier in the week. My colleagues have. I'm not going to get back into the speech that you gave at the Federalist Society. One aspect, well, I mentioned just the one part of it that is of concern. If the administrative agencies are in the federal government, which they certainly are, they have to be in one of those branches, legislative, executive, judicial, and the logical candidate is the executive branch. And the President continues, the President has the power and the duty to supervise the way in which to which subordinate executive branch officials exercise the President's power carrying federal law into execution. So we asked you about that power and that authority, and you responded, as I think you just repeated here, that the Humphrey case was the dominating case on this issue. Am I roughly correct? I'm trying to get through some material. Is it?
It was yes, it was the leading case, and it was followed up by later
Morrison.
cases.
Followed up by the Morrison case as the controlling case on these administrative agencies. But what you haven't mentioned to date is that the theory, what you haven't mentioned to date is your dissent from the Morrison case. We've been trying to gain your view about the unitary presidency. Most people believe we have an executive, legislative, and judicial, and now we have this unitary presidency, which many people don't really kind of understand. And it sounds a little bizarre. We want to know about, you've indicated support for it, you've commented back and forth about it, you've indicated the controlling cases that establish the administrative agencies. You refer to the Morrison case as being guiding the authority. But then in the Morrison, at your comments about the Morrison, you say, you then proceed to outline a legal strategy for getting around Morrison. This is what you said. Perhaps Morrison decision can be read in a way that heeds, if not the constitutional text that I mentioned, at least the objectives for setting up a unitary executive. That could lead to a fairly strong degree of presidential control over the work of the administrative agencies in the area of policymaking. Our questions in this hearing is, what is your view of the unitary presidency? You've responded at a number of our people, but we were interested in your view and your comments on the Morrison case, which you say is the controlling, but we want to know your view, and it includes these words: that could lead to a fairly strong degree of presidential control over the workings of the administrative agencies in the areas of policy making. Now, that would alter and change the balance between the Congress and the President in a very dramatic and significant way, would it not?
I don't think that it would, Senator. The administrative agencies, the term administrative agencies is a broad term, and it includes
The Federal Reserve?
it includes agencies that are not regarded as so-called independent agencies. It includes agencies that are squarely within the executive branch under anybody's understanding of the term. Agencies that are headed by a presidential appointee whose term of office is at the pleasure of the president. And that's principally what I'm talking about there, the ability of the president to control the structure of the executive branch, not agencies. The term administrative agencies is not synonymous with agencies like the FTC, which was involved in the Humphreys Executor case, where the agency is headed by a commission and the commissioners are appointed by the president for a term of office, and there are conditions placed on the removal of the agency, of the commissioners.
Well, the point, Judge, the answer you gave both to my colleague Senator Leahy Durbin and to me, that, and the quote, the concept of a unitary executive does not have to do with the scope of executive power, really was not accurate. You're admitting now that it has to do with the administrative agencies, and this would have a dramatic and important reconsideration of the balance between the executive and the Congress. I haven't got the time to go all through, but we're talking about the Federal Reserve, Consumer Product Safety, the Federal Trade Commission, a number of the agencies that would be directly considered and that have very, very important independent strategy.
Senator, as to the agencies that are headed by commissions, the members of which are appointed for terms, and there are limitations placed on removal, the precedents, the leading precedent is Humphreys Executor, and that is reinforced, and I would say very dramatically reinforced by the decision in Morrison, which did not involve such an agency. It involved an officer who was carrying out what I think everyone would agree is a core function of the executive branch, which is the enforcement of the law, taking care that the laws are faithfully executed.
But the point here is you take exception to Morrison. You're very clear about, we're interested in your views. We understand the Humphreys, Morrison are the guiding laws, but we've talked about stare decisis and other precedents. But you have a different view with regards to the role of the executive now, an enhanced role, what they call the unitary presidency, and that has to do as well with the balance between the executive and the Congress in a very important way in terms of these administrative agencies. I haven't got the time to go all the through, but we did have some discussion about those agencies and how it would alter the balance of authority and power between the Congress and the executive. That's very important. I mean, it's enormously interesting. We've had Professor Calabresi from Harvard University spelt this out in great detail now. And I know you've separated yourself a bit from his thinking, the extent that he would go in terms of administrative agencies. The point is, there'd be a different relationship if your view was the dominant view in the Supreme Court between the executive and the Congress, and that's really the point.
Well, Senator Kennedy, what I've tried to say is that that I regard this as a line of precedent that is very well developed, and I have no quarrel with it, and it culminates in Morrison, in which the Supreme Court said that even as to an inferior officer who's carrying out the core executive function of taking care that the laws are faithfully executed, it is permissible for Congress to place restrictions on the ability of the President to remove such an officer, provided that in doing so there is no interference with the President's authority. And they found no interference with that authority there. And that is an expression of the Supreme Court's view in on an issue that's where the claim that there should be no removal restrictions imposed is far stronger than it is with respect to an independent agency like the one involved in Humphrey's executive.
Well, the point is that you've differed with the Morrison and outlined a different kind of a strategy. I want to move on. I want to come back just briefly again to the Vanguard issue, which continues to trouble and puzzle me by your answers to me and others. Now, just to get back to the starting point, in your sworn statement to the committee when you were nominated to the Circuit Court in 1990, on page 15 of that statement, you wrote this about your recusal practices. I do not believe that conflicts of interest relating to my financial interests are likely to arise. I would, however, disqualify myself from any cases involving the Vanguard companies. So, according to your sworn promise, you were going to recuse yourself from cases involving the Vanguard companies. Is that correct?
I said I would disqualify myself from any cases involving the Vanguard companies.
All right. You also said you'd recuse yourself from any case involving your sister's firm,
That's
in case in which you were involved in the U.S. Attorney's Office.
That's
Is that correct?
Yes, that's correct.
And there's been some discussion as to whether that commitment covered only the initial period of your judgeship, and I'm not going to go on into that. I'm not going into that. I just want to know about the steps you took to meet your commitment to the committee, even in the initial years. On Tuesday, you told Senator Feingold that you had no recollection of whether you put Vanguard on your recusal list when you were first appointed to the bench in 1990. Is that still right?
That's correct. I don't have the initial list that was submitted to the clerk's office, and I think I clarified in response to Senator Feingold's question that is a list that is used by the clerk's office to make the first cut on recusal issues, but it is not by any means the last word.
Okay. And in 1990, you owned 80,000 of Vanguard funds. Is that right? And over the year, it grew to hundreds of thousands. Is that correct?
It grew, yes.
Okay. So you were getting reports from Vanguard now, either monthly or quarterly or annually? Were you not reporting?
Yes, I was.
All during this period of time?
Yes.
Do you know whether Vanguard was on your recusal list in 1991?
I don't know what was on the list that was with the clerk's office prior to the time when the system was computerized, and I have seen recently, and I believe you have, copies of the lists that were on the computer, and those lists do not include Vanguard. There's no question about that.
We received your standing recusal list from the Third Circuit earlier this week. It's dated January 28, 1993, and Vanguard is not on it. You have your sister's law firm on it. You have your cases from the U.S. Attorney's Office on it, but not Vanguard, your largest investment. And here are the recusal lists for 1994, 1995, 1996, and Vanguard is not on any of them either. Do you have any reason to disagree with the report from the clerk of the court?
I don't, Senator. I don't know whether I have no comment on the list. That's the list that they had. I don't know exactly how that list came about, but that's the list they have.
What does it say at the top of one 2893 list under the date? As I understand, it says no changes.
As of 1/28/93, no changes. That's
so.
correct.
This was 93, so there were no changes in that from 92, and you've listed probably 8 or 9 different items on there, have you not?
There are 8 items listed.
Okay. So you've got 8 items on there. Vanguard isn't on, and it says no changes in the previous year. So I assume that means 92 list was the same, so that you did not have Vanguard on the 92 list either. Do you remember whether you ever placed Vanguard on your recusal list at any time between the time you were sworn in and January 1993?
As I said, I don't have a copy of lists that predate this. In fact, I didn't have a copy of these lists, and I don't know, obviously, I can't recall what was on the earlier lists.
Well, in 1994, you removed the U.S. Attorney's Office from your recusal list. Is that right?
Yes.
So you did revisit the recusal list at that time.
I notified the clerk's office to take the U.S. Attorney's Office off the list. I actually think I have a copy of the letter that I sent there. I don't believe that I looked at the list and crossed it off the list. I sent them a letter, and I outlined, I said, that's now been 4 years. This was another instance of my going beyond what I had to do.
Yeah.
I recused myself in everything from the office, not just things that were there while I was in office, but after the passage of 4 years, I thought that the cases that I had had any possible connection with had washed out, and so I sent a letter, and I have a copy of the letter, saying, take it off this list, but notify the U.S. Attorney's Office and the Public Defender's offices that they should notify the clerk's office if any case comes up in which they have any reason to believe that any aspect of the case was in the U.S. Attorney's Office while I was there.
Well, I just mentioned one of the things you had to do was put Vanguard on the list, was it not? Because you gave the assurances to the committee, sworn testimony, that you were going to recuse yourself. That was one of the things.
Senator, if it was not on the initial list, then that would be an oversight on my part. I said in answering the question to the Senate, I don't believe conflicts of interest are likely to arise. They really rarely do arise with respect to mutual funds. That's one of the main reasons why judges and other people who have to worry about conflicts invest in mutual funds. And no Vanguard case came before me, no case involving Vanguard came before me for 12 years.
Well, the point is the judges, as I understand and as their responsibility, take the whole issue on recusal extremely seriously and review those lists very, very carefully. And given the assurances and the pledge and the promise under oath to the committee, and not to find out that it's on your list. And over the period of these last weeks, we've heard so many explanations, Judge. This is what confuses us. We heard, first of all, that it's a computer glitch. And then we hear, well, it doesn't really apply because it's an initial service list. So Vanguard really didn't, I wasn't in it because I didn't make the decisions on it till after I'd been in 12 years. I made the pledge to the committee. I don't know how many years, how good that pledge was, for how many years it was good, but that initial pledge, initial service meant I didn't have to do it. And then we heard the excuse, well, it was a pro se case, and we had different computers. That was what was mentioned in my office. It's a pro se case. We have different computers. There are different computers in the clerk's office than exist in the law firms here in Washington from all over the country. I could never quite understand it because a pro se, obviously, talking about individuals, you'd think that that might even have a higher kind of a requirement. But the facts are that you never put that Vanguard on your recusal list. And all of these papers were in your control. And that, I think, is a matter of concern should be to all of us for the reasons.
Senator, could I just
yes.
say a brief comment on that? I've tried to be as forthcoming in explaining what happened here as I possibly could be, and I am one of those judges that you described who take recusals very, very seriously, and I served for 15 and a half years. I sat on the merits on well over 4,000 cases. In addition to that, let me just mention the statistics for a recent year, and I think these are typical of my entire period of service. During the last calendar year, I received over 500 petitions for rehearing. Most of those are in cases I didn't sit on initially. Over 400 motions. Most of those are in cases that I didn't hear on the merits. And many of those are just as important as appeals on the merits because they involve things like whether someone is going to be removed to a country where the person claims that they will be subjected to persecution, or their applications by habeas petitioners for permission to file, to proceed with, to take an appeal in a habeas case. And if we don't issue the certificate of appealability, that's the end of the matter for that petitioner who may be serving a very lengthy sentence or a life sentence. So we're talking about well over 1,000 cases a year. Now, and this is over a course of 15 years. This manga case is one case, and I've said there was an oversight on my part in not focusing on my personal practice when the issue came before me, and when the recusal issue was brought to my attention, I did everything that I could to make sure that nobody could come away with it from this with the impression that Ms. Maharaj got anything other than an absolutely fair appeal.
Well,
and I've tried to explain the whole thing. I have not given conflicting answers, but I've been asked a number of different questions, and there are a number of steps that were involved in what took place. The fact that it was a pro se case I mention that not because pro se cases are any less important than any other category of cases. They're very important, but it is the fact that our court uses a different system. For pro se cases, we don't have these clearance sheets, and that's when I have typically focused on the issue of recusal.
Well, I thank you, Judge. I think if we had in the beginning, we all made mistakes, and all of us, and I've certainly made more than my share, but when we have a statement on this, I think we could have cleared this whole up in the very beginning. If it just said it was a mistake, it wasn't on the list, I should have been on the list, as we're saying now. We would never have had to get all this, but go through this. But we've had a series of explanations. The light not going off when I looked over the Vanguard case, the computer glitches, the changes of the computers. I wasn't told so by my clerks. We had all of those statements, and so this was what troubles many of us on the committee about getting the straight answers on an issue which is of a great importance. Mr. Chairman, I want to just, and we'll use the remainder of my time with a brief comment. I want to thank our chairman for the fair and dignified way that he's conducted the hearing. I thank our ranking Senator Leahy for usual courtesies as well, and I thank Judge Alito for your willingness to serve. And thanks to your family for being here and for the support they've given throughout these hearings. These stakes are very high, and that was reflected in the variety of questions posed over the past 3 days. We started these hearings seeking answers. We've come with even more questions about Judge Alito's commitment to the fairness and equality for all. Unitary executive. We discussed Judge Alito's expansive views on presidential authority. He distanced himself from the theory of the so-called unitary executive, one that promotes extremely expanded executive power. He gave the committee the platitudes about Supreme Court precedent and the Constitution, but his comments before this committee run away from his statements of the past, some as recently as 5 years ago, that embrace this very radical and, I believe, bizarre theory. Professor Stephen Calabrese, one of the originators of the unitary executive theory, says that the impact on this nation is vast and dramatic. It obliterates the independence of agencies that protect the public, such as the Consumer Product Safety Commission, the Election Commission, Security Exchange Commissions, and much more. It makes no sense to describe the effects of this bizarre theory in any other terms. That's how its founders brazenly described it. But somehow Judge Alito expects us to buy his unique and lonely portrayal of this radical theory as something less than it is. On the Concerned Alumni of Princeton, much has been made of the wide interest in Judge Alito's interest in this organization and its frankly bigoted views. I was pleased that Judge Alito distanced himself from its repulsive, anti-woman, anti-black, anti-disability, anti-gay pronouncements, views that we especially pronounced at the time that Judge Alito believes he joined. But we still do not have a clear answer to why Judge Alito joined this reprehensible group in the first place. We still do not know why he believed that membership in the group would enhance his job application in the Reagan Justice Department. We still don't know why he chose this organization among so many other organizations that he likely belonged to, but somehow can't remember why. In the Vanguard, some of our Republican colleagues find it shocking that we would even question Judge Alito's about his failure to recuse himself from Vanguard cases, but the real shock is that Judge Alito failed to meet his sworn promise to this committee more seriously. He says it was an oversight, that he corrected 12 years after he made that promise. But now we know from his own testimony and records that he apparently never put Vanguard on the recusal list, even immediately after his promise to this committee. He has failed to give us any plausible explanation. The bottom line is that he just didn't think his commitment to the committee and to the United States Senate was important enough to honor. In the 1985 job application in my office, Judge Alito tried to distance himself from the ideological views and legal opinions expressed in the 85 job application to the Reagan Justice Department. He brushed it off as just a job application. Now he has tried before the committee to distance himself from the stunning statement that the White House and Congress somehow are superior to the Supreme Court, the keeper of our liberties. He didn't back away 1 inch from his view that a woman's right to make her own reproductive decision is not protected under the Constitution. He didn't back away from his criticism of the principle of one person, one vote. And on the cases, he decided, in case after case, we see legal contortions and inconsistent reasoning to bend over backwards to help the powerful. He may cite instances to think that he helped the little guy, but the record's clear that the average person has a hard time getting a fair shake in Judge Alito's courtroom. We're not expecting judges to produce particular results in their decisions, but we do expect fairness for understanding the real-world impact of their decisions. Frankly, it'd be more comforting if Judge Alito gave individuals the same benefit of the doubt in his courtroom that he's asking from this committee on Vanguard, CAP, the unitary executive, and women's privacy. Now the debate over the nomination continues. In the end, this debate really is about the path of progress and the kind of America we hope to become. America is noblest when it is just to all of its citizens in equal measure. America is freest when the rights and liberties of all are respected. America is strongest when all can share fairly in its prosperity. And we need a court that will hold us true to these guiding principles today and into the future. Thank you very much, Mr. Chairman.
Thank you, Senator Kennedy. Senator Hatch has stated his wish to reclaim at this point some of his reserved time. Senator Hatch?
I don't intend to be very long, but I really believe that bringing up Vanguard or the Princeton matter goes beyond the pale at this point in this hearing. And let me just make this case. Some of your critics, Judge, have focused on a lot of attention on the actions over the Vanguard matter. And I think this is, and I think most people who think this is really a case of much ado about nothing. Certainly no law required you to recuse yourself in that case. As a matter of fact, the law helped put together by one of the leading Democrat ethicist professors of law reads as follows: financial interest means ownership of a legal or equitable interest, however small, or a relationship as director, advisor, or other active participant in the affairs of a party, except that ownership in a mutual or common investment fund that holds securities is not a, quote, financial interest, unquote, in such securities unless the judge participates in the management of the fund. Now, you did not participate in the management of the fund, right?
No, I certainly did not.
Okay. That's what the law says. So what's this big case that's being made? It must be that since you signed, among dozens of pages, the committee form that says in the initial service you agreed to recuse yourself in the Vanguard matter, and then you made a mistake later, 12 years later, which you rectified. In other words, you lived up to your word in every sense of that term, whether or not you considered the initial service or not. But anybody who looks at it would have to say, my gosh, that doesn't mean 12 years from now. But you even ignored that and said, I recognize that I made a mistake, I recused myself even when I didn't have to recuse myself, and did everything I could to live up to that, my word, which you did. In other words, you lived up to your word. That's a fair interpretation, isn't it?
It is, Senator. I said even if you read the answer as setting out a promise that would exist, that would be binding on me for the entire term of my judicial service, and I did disqualify myself in the only Vanguard case that ever came before me.
And so to imply somehow or other that you were dishonest because you lived up to your word in the end, I think is a little bit beyond the pale. The ABA reviewed this matter and found that you have an excellent record for integrity. You earned for the second time the highest American Bar Association rating of well qualified. Now, I put in the record yesterday letters from several ethics professors who have examined this issue and found nothing improper. They agree that you lived up to your word and you didn't have to, nor will you have to in the future. That's what that law says in 28 U.S. Code Section 455 D4I, or D4I. That's what it says. Now, I might add that included a letter from Professor Jeffrey Hassard. Back when Justice Breyer was up for confirmation and questions were raised about the propriety of him hearing a case in which some argued, falsely I think, that he had a financial interest, my friend from Massachusetts, Senator Kennedy, favorably cited a letter from Professor Hassard that was favorable to Justice Breyer. And by the way, I'm not going to judge the two cases, but it was every bit as much a case as this weak thing that has been brought against you. Now, you know, what is going on here is nothing but an attempt to make a big deal about nothing, a small thing. And I think it's being done with a bit of old bait and switch, if you ask my opinion. I might add that when Judge Breyer, what happened there in the case of Breyer, I reviewed I investigated it, and when the facts showed that he did no wrong, as they show you've done no wrong, I came out of the blocks and defended him. And I'm glad I did, because he, like you, is an honest man. Neither Breyer, Justice Breyer, or you have gone into public service to make money. That's pretty apparent. Now, to have this like you've done something wrong because you made a mistake and then you rectified it, my gosh, how many times do we have to beat that old dead horse? With regard to the other thing, I have my own opinion as to why that's repeatedly brought up when you have adequately explained that you didn't remember much about it or anything at all. Now we find that the Russia memoranda contained no reference to you. He never heard of you before now. And it makes you wonder, why are they bringing that up? Well, I've got my opinions on that. And I think my opinions are right. The fact of the matter is, you've been straightforward here. You've honestly answered the questions. You've answered more questions than almost any Supreme Court nominee in my 29 years in the Senate. And I don't think you've been fairly treated. And it makes everybody wonder, why would anybody want to do these jobs? I know law review graduates who will make more than the Chief Justice this year. New graduates from law school. So it's apparent you're going into this because you love your country. You want to serve it. And you've done it well for 15 years. And anybody who knows you knows that. And I know you. So I think it's just wrong to keep bringing these phony issues up. And you have to ask, well, why are they doing it? Because they're so phony. That's all I care to say to that. I'll reserve the balance of my time.
Thank you, Senator Hatch. Your 18 minutes and 9 seconds will be reserved.
Thank you.
Senator Biden has asked for 20 minutes. We're going to be a little more flexible at this final round because I see light at the end of the tunnel, quite frankly. I see our conclusion of these hearings, probably not tonight, but tomorrow, not too late. We've started all the sessions exactly on time, and we've held to the time limits on the up till now, which I think we have to do if we want to move ahead. If you want to start to slip on when you start or the timing, it just gets out of hand. But at this juncture, on the final round, we have a little more flexibility. I see the light at the end of the tunnel. And Senator Biden, you're recognized for up to 20 minutes, as you have requested, and if you go a little more, my gavel will stay put.
Well, thank you, Mr. Chairman. I'll try not to. Judge, I heard the chairman. I happened to be doing something on Darfur, and I was in the conference room, and I heard the chairman say that, which I agree, he and I have talked about this, nominees tend to answer as many questions as they think they have to in order to get confirmed, and I would say that that's been the case with all nominees, basically, since Judge Bork. I'd also add another, I think, truism that's developed is they tend to answer controversial questions in direct proportion to how much they think the public is likely to agree with them. It all goes to kind of a central point here is what is the public entitled to know about what you think or what anyone thinks before they go in the court. And I realize there's this dynamic tension between your independence as a nominee, what you'd be an independent justice, and answering questions. But having said that, let me go to an area that I hope you'll engage me in. It goes to executive power. I have had the dubious distinction because of my role in the Judiciary Committee and in the Foreign Relations Committee, and the last 3 or 4 times force has been used by a president to be the guy in charge of, at least on my side of the aisle, drafting or negotiating the drafting of the authority to use force, whether it was President Clinton, before that, President Bush, and even before that, the discussion back on Lebanon with President Reagan, et cetera. So it's something I've dealt with a lot. Doesn't mean I'm right about it, but I've thought a lot about it. And now there is a school of thought that's emerging within the administration that is making not illegitimate, an intellectually thought out claim that the power of the executive in times of war exceed that of what I would argue a majority of the constitutional scholarship has suggested. The fellow who is a very bright guy, who is referred to as the architect of the president's memorandum on the ability of the presidents to conduct military operations against terrorists and nations supporting them, is Professor Ho, and I think I'm pronouncing Yu, excuse me, Professor Yu, and he's written a book called The Powers of War and Peace, and he makes some claims that are relatively new among the constitutional scholars in his book, and he had urged when he was at the administration, the president had these authorities. For example, he says that the framing generation well understood that declarations of war were obsolete. He goes on to say, given this context, it's clear that Congress's power to declare war does not constrain a president's independent and plenary right, constitutional authority over the use of force. And he goes on and he argues, as you well know, this argument, I mean, not from your court, just as an informed, intelligent man. There's a great debate now of whether or not the administration's internal position is correct. And that is the president has the authority to go to war absent congressional authorization. And it was a claim made by Bush 1 and then dropped. Bush 1 argued that the only reason the declare war provision is in the Constitution is to give the president the authority to go to war if the president didn't want to. That was the claim made. similar claim made here. So I want to ask you a question. Do you think the president has the authority to invade Iran tomorrow without getting permission from the people, from the United States Congress, absent him being able to show there's an immediate threat to our national security?
Well, that's a question that I don't think is settled by the whole issue of the extent of the president's authority to authorize the use of military force without congressional approval has been the subject of a lot of debate. The Constitution divides the powers relating to making war between the president and the Congress. It gives Congress the power to declare war, and obviously that means something. It gives Congress the power of the purse, and obviously military operations can't be carried out for any length of time without congressional appropriations. Congress is given the power to raise and support an army, to maintain a navy, to make the rules for governing the land and the naval forces. The president has the power of the commander-in-chief. And I think there's been general agreement, and the prize cases support the authority of the president to take military action on his own in the case of an emergency when there is not time for Congress to react.
Is that the deciding question, if the Congress does not have the time to act?
Well, the prize cases, I think, are read to go as far as to say that in that limited circumstance, the president can act without congressional approval. A lot of scholars say that what's important as far as congressional approval is not the form, it's not whether it's a formal declaration of war or not, it's whether there is authorization in one form or another. The War Powers Resolution was obviously an expression of the view on the part of Congress.
Well, if I can interrupt, Judge, since I'm not going to have much time, the War Powers Resolution is a legislative act. I don't want to get into that. I'm talking about the War Clause. And the administration argues, and Ho argues that, quote, I do not think the president is constitutionally required to get legislative authorization for launching military hostilities. And that's a pretty central question. That means the president, if that interpretation is taken, the president could invade, and maybe there's good reason to, invade Syria tomorrow, or invade Iran tomorrow, without any consultation with the United States Congress. And that's a pretty big deal. Up to now, Fisher and Henkin and most of the scholarship here has said, no. The president's authority falls into the zone where he needs it for emergency purposes, where he doesn't have time to consult with the Congress. But you seem to be agreeing with the interpretation of the president, Professor Yu, that says, no, the president has the authority, if he thinks it's necessary, to move from a state of war, or a state of peace to a state of war without any congressional authorization.
Oh, I hope I'm not giving you that impression, Senator, because I didn't mean to say that. I have not read Professor Yu's book or anything that he or anyone else has written setting out the theory that you've described. I've been trying to describe what I understand the authorities to say in this area. Generally, when this issue has come up, or variations of this issue have come up in relation to a number of recent wars, there were a number of efforts to raise issues relating to this in relation to the war in Vietnam. There was an effort to raise it in relation to our military operations in the former Yugoslavia. In most of those instances, the cases were dismissed by the lower courts under the so-called political question doctrine.
That was, as you and I both know, that's a different issue. That the political question doctrine is a different issue than whether or not you think that, I'm asking you as a citizen, whether you think that, as the administration is arguing, for example, it argues that the case is made that I'm quoting that the Constitution permits the president to violate international law when he's engaged in war. It just states it flatly. That's what the memorandum of the Justice Department states flatly. The president has that sole authority. He argues the Congress would have that authority as well, just violate international law. He goes on to argue, as does the memorandum argue, this is this administration's position, so that's why it's relevant. It says that the president may use his commander-in-chief and executive power to use military force to protect the nation, subject only to the congressional appropriations. And that means that the argument the administration is making is the only authority the Congress has is to cut off funds. Let's say we didn't want the president to invade Iran. The administration argues we could pass a resolution saying that do not invade, you have no authority to invade Iran. And the president could say, and the next day invade Iran. Our only recourse would be to cut off appropriations. But as you know, there's no way to cut off specific appropriations. You'd have to cut off appropriations for the entire military, which means it's a totally useless tool for the Congress in today's world, to say, all right, now how do you can't say, well, I'm going to cut off only the money for the oil that allows the steaming of the ships to get from the East Coast to the Mediterranean Sea and or to the Persian Gulf. So it's really kind of important whether or not you think the president does not need the authority of the United States Congress to wage a war where there's not an imminent threat against the United States. And that's my question.
Well, and Senator, if I'm confirmed and if this comes before me, or perhaps it could come before me on the Court of Appeals, the first issue would be the political question doctrine that I've described. But if we were to get beyond that, what I can tell you is that I have not studied these authorities, and it is not my practice to just express an opinion on a constitutional question, including particularly one that is as momentous as this. I've set out my understanding of what the Congress, what the Constitution does in allocating powers relating to war between the executive and Congress, and some of the leading authorities have said on this question. But beyond that, and I haven't read Professor Yu's book or anything that he's written on this issue, I would have to study the question.
I thank you. Well, let me move to something you have spoken about, stare decisis. I know it's been raised a number of times. That's basically following precedent. As a Circuit Court of Appeals judge, in layman's language, what does that mean you're required to, as a Circuit Court of Appeals, what does it mean you're required to adhere to stare decisis?
We are required to follow decisions of the Supreme Court to start out with, because it's a superior court. When we sit as a panel, it is our practice, and I think it's the practice of all the courts of appeals, that one panel can't overrule a decision of another panel. So it means that. When we sit on bank, it is a doctrine that counsels adherence to prior precedent.
But you're allowed in that circuit, like you did in ACLU versus Schundler, you concluded, which you had, I think you had a right to do, that the precedent of your circuit was incorrect, and you ruled the other way.
Well,
I think you have a right to do that, right?
We can't do that at the panel level. We can't say a prior panel decision is incorrect.
No, but you can when you sit in bank.
When we sit on bank, we
when
can.
all the justices
That's correct.
There. Okay, now, how about when for a Supreme Court justice? A Supreme Court justice is not required, is he or she, to follow the precedent of the Supreme Court? There's no, that stare decisis doesn't apply there, does it? Maybe practice, but as a practical matter, no scholar says you're required as a Supreme Court justice to adhere to precedent, are they? Is it?
Well, stare decisis certainly applies. Stare decisis takes different forms. There's what some people call horizontal stare decisis, which means a lower court has to follow the higher court. Vertical stare decisis. there are various forms of horizontal stare decisis, which means a court either must or should follow its own prior precedents. And on the Supreme Court, of course, when we're talking about whether the Supreme Court is going to follow a prior Supreme Court precedent, that's horizontal. And there, it isn't an absolute requirement to follow a prior precedent.
It is not an absolute.
It is not an
Yeah.
absolute requirement, but it is the presumption that the court will follow its prior precedents.
No, I understand that, but no one would argue that if you or any other justice clearly broke from the precedent of a Supreme Court decision, that you're in any way violating your ethical responsibility as a judge. You're entitled to do that. Not that you would, but you're entitled to do that, and no one would question that as a matter of right. Is that not correct?
Well, I think people would question it if you disregarded the factors that go into the stare decisis analysis. If you said, I don't believe in, I'm not absolutely required to follow prior Supreme Court precedent, and I regard every question as a completely open question, I think
Well, I doubt, with all due respect, the way it would likely take the form is a justice to say, I disagree with the line of cases that say that, a president needs congressional authority, or that whatever the line of cases are. They're not likely to say, I disregard stare decisis. And it's like what Scalia said in the abortion. He said, look, we should just look at this head on. Roe v. Wade's wrongly decided. We should just say so. And he's entitled to do that. And if he had a majority, I'm not suggesting what you would do on that. He's entitled to do that, and that wouldn't be a violation of any written or unwritten code that relates to a Supreme Court justice's conduct, would it?
Different justices and different judges have different views about stare decisis, but my view is that you need a special justification for overruling a prior precedent, and that reliance and reaffirmation are among the factors that are important, but I've also said it's not an inexorable command.
Okay.
In the area of constitutional law, there has to be the ability to revisit a case like Plessy versus Ferguson. I don't think anybody would want a system of stare decisis that made that impossible.
Okay, my time's, we're going 3 minutes left. I'd like to try to get quickly to another area here, if I may, that you've been questioned on, this whole notion of unitary executive and the questions referencing Morrison and the dissent of Scalia, et cetera. As I reach and teach the dissent of Scalia, I won't take the time, in the interest of time, to read his exact language. He has a very scathing and intellectually justifiable, many would argue, criticism of the test employed by the majority in that case is to determine whether separation of powers has been breached. He argues there are very bright lines, that there can be no sharing of any of the power. If it's an executive power, it's an executive power, and it's executive power. He would argue that the alphabet agencies, the FDA, the FCC, the EPA, they are really not constitutionally permissible, because the FDA makes a legislative judgment, it makes a judicial judgment, and it imposes fines and penalties. And so therefore it does all three things and is sort of the bastard child. And but most of the majority of the justices say that as long as the power one branch is using does not unduly trench upon the power of the other branch, or it does not substantially affect its ability to carry out its powers, then that's permissible. Which school of thought do you fall into?
Different issues are presented in different factual situations.
That's why I didn't give you a specific issue.
Well, I think you need a specific issue in order to answer it. For example,
Okay, the FDA, is it constitutional? Federal Drug Administration?
I don't know that there are. I don't know whether there are statutory restrictions on the removal of the FDA commissioner.
No, but there are. The FDA does exercise judicial power. It makes judgments. You, drug company A, violated the law.
And I don't know any constitutional objection to that.
Well, Scalia.
I don't know that he would have a constitutional objection to that. My understanding is that he would not have a constitutional objection to their doing that, but I could be mistaken. And I wouldn't want to prejudge any constitutional question that might be presented to me, but I am not aware of a constitutional. If there isn't any limitation on removal, then there obviously isn't a removal issue there. As to the agencies where there are restrictions on the removal of commissioners who are appointed for a term, that issue is dealt with in Humphrey's executor and Weiner and in Morrison, and Morrison was 8-1, and the other cases would be sort of a fortiori from Morrison.
Well, my time's up, and hopefully someone will pursue this unitary executive issue about private suits, because I thought what you explained was a little inconsistent, or I don't understand it, but I'll let someone else do that. Thank you very much.
Well, thank you very much, Senator Biden. Senator Grassley has asked that his time be reserved. Senator Grassley has other duties which he had to attend to. He was here earlier, will be back. He's also chairman of the Finance Committee. Just a word, when senators come and go, everybody has many committees and many constituents and many visitors and many callers. So when they're not here, you can conclude they're otherwise engaged, and Senator Grassley is now, but his time is reserved. Senator Cole has asked for 20 minutes. Senator Cole, we'll set the clock at 20 minutes for you, and as I said earlier, we have some flexibility here.
I thank you very much, Mr. Chairman. Judge Alito, elected officials make decisions on issues every day as we try to best represent the people of our states. And if our constituents do not think that the choices that we make reflect their opinions, then every few years they have an opportunity to vote for someone else. As you know, that's not the case with the courts. Once confirmed, federal judges have lifetime tenure and are virtually unaccountable. And that lifetime tenure can result in a judge or in a court that is removed from the thoughts and opinions of most Americans. As public opinion changes on an issue, the court may cease to reflect the views of the country. If the courts take positions contrary to what most Americans think about an issue or decide a case, very important case, in a way that is clearly out of the mainstream of American thought, what can be done about it? And do you think that the courts need to consider public opinion when deciding cases?
I think that the courts were structured the way they are so that they would not decide their cases based on public opinion. If the framers had wanted the federal courts to follow public opinion, then they would have made federal judges elected officials, as they are as state judges are in many states. They gave them lifetime tenure because they thought there was a critical difference between deciding cases under the Constitution and the laws and responding to public opinion. Now, they gave the courts limited authority because they wanted most of the decisions that affect people's daily lives to be made by the branches of government that are directly responsible to the people, so that the people can control their own destiny. The framers' theory was that sovereignty lay with the people, and the government was legitimate only insofar as it responded to the people, and that's why Congress is structured the way it is. That's why the presidency is structured the way it is. But the courts are not a democratic institution, and they were structured the way they are because they saw a difference between the judicial function and the other functions that are performed by the branches of the federal government.
Well, and yet the courts, particularly the Rehnquist Court, has struck down more laws than any court in recent memory. In response to your comment about the legislatures as being involved in the daily lives of people, and the rate that they've been striking down laws during the Rehnquist Court was 6 times faster during the first 200 years of our republic. So how do we deal with the fact that while the legislature, in your opinion, is supposed to represent the daily lives of people, the courts, particularly Supreme Court in recent years, has been striking down the laws of the legislature more often than ever before?
Acts of Congress are presumptively constitutional, and I don't think that's just, that saying that is just words. I think that means something. Members of Congress take an oath to support the Constitution, and I think that the presumption of constitutionality means a lot, and I think that judgments that are reached by the legislative branch in the form of findings of fact, for example, are entitled to great respect because of the structure of our government, the fact that the basic policy decisions are supposed to be made by the legislative branch and carried out by the executive branch, and also for the practical reason or the functional reason that Congress is in a better position to evaluate conditions in our country and conditions in our society and to make findings and to determine what's appropriate to deal with the social and economic problems that we face. So I would certainly approach the question of determining whether an act of Congress is constitutional with a heavy presumption in favor of the constitutionality of what Congress has done. Now, ultimately, Marbury versus Madison decided the question that when a case or controversy comes before the Supreme Court, the court and the constitutionality of an act of Congress is challenged, it is the duty of the court to decide the question. Unless we were going to go back to 1819, then that's the practice that the federal courts have to follow. But they should always do that with an appreciation of their limited role and the role that the legislature is supposed to play.
All right. Well, as a follow-up to that, would you comment on term limits for federal judges or age limits for federal judges? As you know, if a judge so wishes, he or she can serve forever. Do you think that's a good thing in our society? Should judges be term limited? Should judges at least be age limited? Or should they serve just as long as they wish?
Well, those are issues that are decided by the Constitution. The framers said that federal judges have life tenure. So without amending the Constitution, I don't think you could you could have judges serve for a term of years or impose an age limitation on.
What is your opinion?
On federal judges. I'm not really sure. I understand the arguments in favor of doing both of those things, and state courts do that, and although I said yesterday I didn't think we should look to foreign law in interpreting our Constitution, I don't see a problem in looking to the practices of foreign countries in the way they organize their constitutional courts, and I believe that many of them do have term limitations on the length of service of a member of the highest court and other members of the judiciary. So there are arguments on both sides of the question. If you had a short term of years, you would have a judiciary that was like an elected judiciary, and you would have the advantages and the disadvantages of that kind of structure. But there are arguments on both sides of the question, and it's for other people to decide, not for a member
We're
of the
asking
judiciary.
you, I appreciate that, and I appreciate your thoughtfulness, but again, this is the only time, today may be the last time, that we ever have a chance as a nation to talk to you. So you have a thought on it. I mean, I can't believe you don't have a thought. We're not going to amend the Constitution tomorrow based on your thought that you expressed today, but what is your thought? Do you think it's a good thing for judges to serve unaccountably forever? No age limits, no term limit? Or do you think it might be the best thing for our society, for judges, after a reasonably long period of time, if you so wish, or at a certain age, to phase themselves out?
If I had been a delegate to the Constitutional Convention in Philadelphia in 1787, which is a little hard for me to imagine. But if I had been there and knowing the way things work out, I guess I would narrow the range of possibilities down to, the range of options that I would consider down to either life tenure or a long term of years, so that the judiciary would be insulated from being swayed by popular opinion during a particular period as to the constitutional questions that come before them. And as between those, I'm not sure which I would choose. If the judiciary is going to exercise the power of judicial review in enforcing constitutional rights, then I would think that one of those two options would be the best. But I wasn't in Philadelphia in 1787, so I have a say on that question.
Mr. Holm was still on the committee.
Yeah, that's right. That's right.
Judge, at the end of its term last year, in a 5-4 decision, the Supreme Court ruled in Kelo versus City of New London that it was constitutional for local government to seize private property for private economic development. Many people are alarmed about the consequences of this ruling because, in the words of Justice O'Connor, under the logic of the Kelo case, quote, nothing is to prevent the state from replacing any Motel 6 with a Ritz-Carlton, any home with a shopping mall, or any farm with a factory, unquote. So what is your view of the Kelo decision, Judge Alito?
Well, what I can say is that it's a precedent of the court, and it built on the Midkiff decision, which had been handed down a number of years earlier. I know that it touches some very sensitive nerves, because when someone's home is being taken away using the power of eminent domain, that is a blow to a lot of people, even if they're going to get compensated at fair market value for their home. The home often means more to people than just dollars and cents. It's a place that often involves a lot of emotion. They have emotional attachments to it. They've lived in it a long time. They're familiar with the neighborhood. They want to be with the neighbors. They want to stay in the same area. They may have emotional attachments to things in the home. So it's a tremendous blow. And I suppose that I would imagine that when someone's home is being taken away, a modest home, for the purpose of building a very expensive commercial structure, that is particularly galling. But Kelo was a decision of the court, and I've discussed my view about stare decisis. And should that issue come up again, then obviously the stare decisis factors would have to be considered as the first instant. The stare decisis question would have to be the first question addressed, and the factors that I've discussed would have to be weighed.
Well, your comment is on the one hand and on the other hand, and I do appreciate that. But I've asked you if you would venture an opinion. More precisely, specifically, do you agree in general with Justice O'Connor's dissent?
Well, Senator, I don't think I can answer that beyond what I've said. If the issue were to come before me, and if I'm confirmed, then I would first have to consider whether there's any reason for not following Kelo, which is a precedent of the Supreme Court, and grew out of the earlier precedent that I discussed, that I mentioned. Now, I'm not suggesting that which way I would decide that question of stare decisis, but that is the way our legal system works, that decisions are presumptively to be followed, and I would have to address that question. And if I got beyond it, I would have to go through the whole judicial process that is set up so that questions of constitutional law and other questions are decided in the best way. And reading the briefs, listening to the arguments, participating in the conference, and only after that reaching a decision on the merits of it.
All right. As a follow-up, Judge Alito, if confirmed, you'll be replacing Justice O'Connor, who is a justice who will be remembered by history as one of the most influential justices of the 20th century. She's also, as you know, a much-beloved person. How will you be different from her, Judge Alito? How do you think Justice O'Connor ought to be remembered, Judge Alito? And how are you like or not like Justice O'Connor as a judge?
She certainly will be remembered for many reasons, and I think with great admiration by, I think she is held in great admiration by the American people at this time, and I think that when people look back, they will have great admiration for her work. She obviously was a pioneering figure and was an inspiration for many people who want to pursue legal careers and other careers. She's been a very dedicated justice and has been known for her meticulous devotion to the facts of the particular cases that come before her, and her belief that each case needs to be decided on its complex facts, and that's something that is an important part of our judicial process. I would try to emulate her dedication and her integrity and her dedication to the case-by-case process of adjudication, which is what I think the Supreme Court and the other federal courts should carry out. I think that's that is a central feature of the best traditions of our judicial system.
She was seen as someone who, in a general way, was at the center of the court. You never had an idea whether she might look a little left or a little right, but she was seen as the center of the court, which, as you know, is central to your nomination. And you've said you had great respect for her. You've said you respect her as a justice who did look at the facts, made judgments based on those facts, which is, I think, you would say about yourself. Umpire calling balls and strikes pretty much as they see them. Do you see yourself as a justice, if you're confirmed, who in many ways will fill the same role as Justice O'Connor has filled?
I think that anybody who is appointed to any judicial position has to be himself or herself, and I don't think that anybody can try to replace the person, can duplicate the approach of the person who that person is replacing. We all have to proceed in accordance with our own abilities and our own outlook, and so I don't think that I think we all have to be who we are, but I think we can emulate the great jurists of the past, which is not to say that we can equal them, but we can look at what they've done and see the things that they've done very well, and try to approach what they've done in various areas. And I think that I certainly would try to emulate Justice O'Connor in the ways that I've described. I wouldn't flatter myself to say that I could equal her in any of those ways, but I would certainly try to emulate the way in which she's gone about the conscientious and dedicated and dignified way in which she's gone about the performance of her judicial duties.
You may have answered this question already, but as I said, she was at the center of the court, at least viewed as a person at the center of the court, and served a very useful purpose in that respect. Is it, in your opinion, likely that you might turn out in a general way to be that kind of a justice?
I can only answer that really by saying what I think I've said before, which is that I'd be the same sort of justice in the Supreme Court that I've been a judge, as I've been a judge on the Court of Appeals. I am my own person with whatever abilities I have and whatever limitations I have, and I think if anybody looks at my record on the Court of Appeals, they can get an idea about the way I approach the work of being a judge, and that is what I would try to do in the Supreme Court. And I don't think I can do anything other than that. And that's what I think I should do, and that's what I would do if I'm confirmed.
Judge Alito, I thank you very much. Mr. Chairman, I thank you very much.
Thank you, Senator Cole. We'll take our break now and resume at 10 minutes after 11.
Judge Becker, we spoke on the phone.